Welcome to Iowa Pulse, where we keep you on the record and in the know. I'm your host, and today we're on a mission. We're doing a really deep dive into the U.S. 212 beef litigation. And I know what you might be thinking. Commercial litigation sounds like a cure for insomnia, but you need to stay with me on this one. This isn't just some corporate squabble in a boardroom up in Minnesota. The roots of this story, they run deep into Northwest Iowa soil. We're talking about millions of dollars, a massive beef processing plant, and a group of local investors from places like Sibley, Sanborn, Paulina, and Rock Valley. People who found themselves in the middle of just a legal firestorm.
It is great to be here, and you're absolutely right to emphasize that local connection. This isn't some abstract case. This is about livelihoods, family legacies. I mean, significant capital from Iowa families. We're looking at a case court file, a 65 CV 2414 for anyone who wants to look it up. That is really a masterclass in what happens when a business partnership just goes toxic.
Toxic is, putting it mildly. I was reading the judgment that just dropped, 2 days ago, February 9th, and it reads like a thriller. You've got a struggling beef plant. You've got a secret bank account with $9 million just flowing through it.
Unbelievable.
A hostile takeover, a quote-unquote civil war between the partners. It is just messy.
It has all the elements for sure, high-stakes drama. But at its heart, this whole story is about something called fiduciary duty. That's really the core idea we need to unpack. It's this conflict between a majority group of shareholders who, they felt they were the only ones trying to save a sinking ship, and a minority group, our Iowa investors, who felt like they were getting pushed overboard without a life jacket.
Okay, let's unpack this then. Before we get to the secret accounts and all the courtroom drama, we need to understand the board. Who is who? Because the structure here seems almost designed to be complicated. I kept seeing all these different company names.
It is complicated, but it's a pretty common setup, actually. It's often called an OpCo-PropCo structure. So you have to imagine two distinct circles. First, you have U.S. 212 Beef Corporation. That's the OpCo, the operating company. They're the ones buying the cows, processing the beef, selling the product. They're the engine.
Okay, so that's the actual business, the butcher shop, basically.
Correct. Then you have Minnesota Property Holdings, LLC. That's the PropCo. They're the landlord. They lease the physical facility itself up in Buffalo Lake, Minnesota. So, to use a simple analysis, US 212 Beef is the driver driving the car.
And Minnesota Property Holdings owns the garage the car is parked in.
You got it. Exactly.
Right, and you do that for liability, usually.
Mm-hmm.
If the driver crashes the car, you don't want to lose the garage.
Precisely. It separates the assets. But here's the thing. In this case, the investors we're talking about, the minority group, they had stakes in both. We're talking about plaintiffs like Eugene Hoyer, the Beskow family, David, Gary, Mark the Crotums, the Rordas, the Vanessas. These are the folks with those deep ties to Northwest Iowa. They bought into this whole vision back in June of 2020.
But that vision got pretty blurry, pretty fast. Looking at the financials and the court documents, the picture gets grim almost immediately.
It does, and you have to look at the timing. June 2020. Think about where the world was then. They launched right into the middle of the COVID era. Supply chains were a mess, labor was scarce, markets were just incredibly volatile. By late 2022, the company had racked up a net loss of over $17 million.
$17 million, wow. That burns through capital fast.
Yeah.
But it wasn't just the operations losing money, was it? The garage, as we're calling it, was expensive too.
Incredibly expensive. The landlord entity, Minnesota Property Holdings, they had a lease to pay $5 million a year to the property owner. So you have this huge payment clock ticking. The operating company is losing money on every single cow. And then here's the real kicker. The investors had all signed personal guarantees.
Okay, let's pause on that because that is the absolute nightmare scenario for any business owner. It's one thing to lose your investment. It's another thing for the bank to come after your house.
That's exactly what it is. A personal guarantee pierces that corporate veil. It says, if the company can't pay, I will pay. And Pioneer Bank eventually came calling. They demanded near $3.9 million from these investors personally. So the pressure cooker was, it was fully pressurized. And that's what leads to the fracture.
The Civil War. This is where the majority and the minority really split. The company's bleeding cash. So the majority group people like Chris DeRocher, the Ravelings, they start putting more money in.
They're called capital calls. It's when you go back to the owners and say, hey, we need more fuel for the fire. Everybody chip in. The majority group paid. The minority group, our Iowa investors, they refused.
So why refuse? If you have a personal guarantee hanging over your head, wouldn't you want to save the company to avoid that?
Well, it's a mix of ability and strategy. Some probably just didn't have millions of dollars in loose change. But legally, the minority group felt they were being squeezed out. They argued the majority was mismanaging everything. Their view was basically, why should I throw good money after bad if I don't trust the people driving the car?
It's a standoff. But usually if you don't pay a capital call, you just get diluted, right? You own a smaller piece of the pie.
Exactly. Your ownership percentage just drops. But the majority group, they weren't satisfied with just owning a larger piece of a failing company. They felt that since they were the only ones keeping the lights on, they should be the only ones to benefit if it ever turned around.
And this is where they decided to get creative.
Creative is a very generous word. The court called it a breach of fiduciary duty. So here's what happened. They formed new companies. You see names like 212 Beef Production and 10,000 Lakes Beef.
10,000 Lakes Beef. Sounds nice in Minnesotan. But this wasn't just a rebrand, was it?
Oh, no. This is what's called phoenixing. In May of 2023, the majority group just executed a transfer. They moved the operations, the customer list, the USDA registration, everything that made the business a business from the old company into this new 10,000 Lakes Beef entity.
Wait, walk me through that. You
Yeah.
can just do it. Can you just take the engine out of my car and put it in a new car that I don't own?
Well, you can if you pay fair market value for the engine, but that's the critical point here. They didn't pay the old company anything for those assets. They didn't buy the business. They just took it. They literally told customers to start paying the new company.
So the old company, the one the Iowa investors still own a piece of, is just an empty shell.
An empty shell holding all the debt. That's the move. You let the old company burn to the ground with the debts and the minority partners still inside, while the new company, 10,000 Lakes, rises from the ashes debt-free. And the court looked at this and said, absolutely not. You have a duty to all the shareholders, not just the ones writing checks this week.
Okay, we are definitely going to get to the judge's remedy for that because she did not let them get away with it. But first, we have to talk about the wild card. Because while this civil war is happening, something really strange is going on in the engine room. Enter Brian Lilly.
Ah, yes. The Brian Lilly component. It's fascinating. It's like a whole separate case within the main case. Lilly was a salesman, originally on a $90,000 salary, but he was very well connected, especially in export markets. He eventually became a shareholder himself.
And while everyone else is fighting over who controls the company, Lilly apparently had his own unique ideas about banking. I was reading the findings of fact, and my jaw just dropped. He opened a bank account under the name Enterprise Holdings Group, DBA US 212 Beef Exports.
Right, a DBA or doing business as account. So to a customer paying an invoice, it looks totally legitimate. It says US 212 Beef right on it. But this account wasn't controlled by the company. It was controlled only by Lilly.
And here's where the numbers get just staggering. The court documents say that from June 2021 to December 2022, about $9 million went into this account. But only $3 million of that was ever transferred to the actual company.
Which leaves, what, $6 million unaccounted for? Or at least not in the corporate account where the other shareholders could see it. The majority group naturally accused him of theft. They thought he was siphoning off millions while they were struggling to just pay the electric bill.
On paper, it looks like embezzlement, right? I mean, clear as day. If you take customer money and put it in your private account, that's theft. But here is the real shocker. The jury's verdict was not what you'd expect.
It's a very nuanced verdict, and it really highlights this legal nightmare called commingling. The jury did find that, yes, Lilly breached his fiduciary duty as a shareholder, but, and this is the big but, they found he did not commit civil theft, and he did not cause financial harm to the company.
How is that even possible?
Yeah.
$9 million in, $3 million out. That is a $6 million hole. How can a jury say that didn't harm the company?
It all came down to the chaos of the company's books. The expert testimony just highlighted inconsistencies and irregularities. Essentially, the company's financial records were such a mess that the defendants couldn't prove whose money was whose.
So it's the fog of war defense. It was too chaotic to prove anything.
In a way, yes. Lilly argued that he was using those funds to keep the lights on, paying vendors, paying for logistics, doing the job the company couldn't afford to do. Because he commingled the funds, mixed his money with company money, and the company had no clean records to prove otherwise, the jury just couldn't say for sure that he stole it.
That's wild. So because the company was so disorganized, they couldn't prove he robbed them.
In civil court, the burden of proof is on the accuser, and they couldn't meet that burden. So Lilly and his company, Best Beef Ventures, they walked away largely unscathed on damages, even though everyone agrees that account was shady, to say the least.
Unbelievable. Okay, so let's fast forward to right now. February 2026, Judge Amy Dahl issues her judgment on February 9th. What's the bottom line for our Iowa investors?
It's a huge legal victory, but you have to contextualize it. The judge ruled that the transfer of assets to 10,000 Lakes Beef was a clear breach of fiduciary duty. You just can't do that.
So what did she tell them to do?
She ordered an unwinding. Basically, she told the majority group, put it all back. 10,000 Lakes has to return everything to US 212 Beef. The property, the accounts receivable, the customer lists, the USDA number, all of it.
Like hitting undo on a massive corporate deal.
Exactly. Or she gave them an alternative where US 212 Beef could just take shares in the new company. But the point is, the value that was taken has to be restored to the original company, which means the Iowa investors get their stake back.
And there was also something in there about preferential loans. Can you explain that? It seemed important.
Oh, this is huge for the balance sheet. So back in 2022, the company repaid loans to the majority members, but not the minority members. Then the majority took that cash and immediately put it back into the landlord company as a capital contribution.
Why does that label matter? Loan versus capital contribution.
It's all about ownership. A loan is just debt. A capital contribution gets you more equity. You own more of the company. So they basically use the company's own money to pay themselves back, then use that same money to buy a bigger piece of the pie, diluting the Iowa group.
That is devious. It's like using your friend's money to buy the house you both live in.
And the judge saw right through it. She ordered it reversed. That money has to be treated as loans again. It stops them from artificially inflating their ownership. It restores the balance.
We should also mention the attorney, Bruce Phillips. He wasn't just the lawyer. He was the CFO and the brother-in-law of one of the main partners.
A recipe for disaster. And the jury found he committed legal malpractice. When you wear that many hats, attorney, CFO, family member, it's almost impossible to maintain objectivity. And he was found to have caused damage because of those conflicting roles.
It just seems like every single guardrail that's supposed to exist in a corporation was ignored.
It was the Wild West, and that's why this judgment is so important. It enforces those guardrails.
So let's land the plane. The Iowa Pulse headline is about the verdict, but what's the reality on the ground? The Biscouse, the Roerdas, Hoyer, they won this lawsuit. They got the company back. But what did they actually get back?
That is the pivotal question, isn't it? They fought and they won the right to reclaim their share of US 212 Beef. But remember what we said at the start. In 2022 alone, this company lost $19.5 million. It has massive debts. The bank is still calling in those personal guarantees.
So they won the right to own a burning building.
In some ways, yes. It's what you might call a Pyrrhic victory. The judgment is a huge vindication of their rights. It sets a precedent. But economically, the business itself was failing because of the market. The price of cattle, demand from China, those things didn't change because of the lawsuit.
And those personal guarantees are still out there. The judgment fixes the corporate theft, but it doesn't pay off the bank.
No. The judge's order moves assets back, which might help the company pay its debts. But if the company is still insolvent, the banks are still going to look at those guarantees signed by the Iowa investors.
It's a really sobering thought. You spend years in litigation, you pay lawyers, you prove you are wronged, and you might still be on the hook personally.
It's the harsh reality of business.
Yeah.
But for the integrity of corporate law, this ruling was necessary. You can't let majority shareholders just restart the game when they're losing.
So what happens now? Can they actually restart operations, or is this just about liquidating whatever's left?
Given the state of things, it's really hard to see a path where they all hold hands and start processing beef again. This judgment likely just sets the stage for a final liquidation or a sale where everyone gets their fair share of the scraps instead of one group taking the whole meal.
A fair share of the scraps. A tough way to end a business that started with such high hopes. But I suppose a fair share of scraps is better than nothing at all.
It is, and thanks to this verdict, the Iowa investors, they have a seat at the table to decide how this ends. They aren't just being left in the cold.
And that's what we do here at Iowa. Dig past the headlines to see what it all really means. We want to thank you for tuning in to this deep dive on the US 212 beef verdict.
It was a complex one, but an important one. Thanks for having me.
Absolutely. New briefings are available regularly to keep you informed on this and other stories impacting our region. Thanks for listening to Iowa Pulse. We'll catch you on the next one.